Did you know that in Quitman, Georgia, it is actually illegal for chickens to cross the road? So next time you hear that, why did the chicken cross the road joke, know that in some states, that chicken is breaking the law. I'm Lee Merritt, and this is your legal briefing with Lee, the movement lawyer. So this week on your legal brief, we'll be discussing three things. First, what I call melting the ice. That's suing and prosecuting ICE agents in criminal and civil courts. Then we're going to turn our attention to the fight between state power and federal authority, as the two are clashing all over the country on issues of immigration and civil liberties. Lastly, we'll turn our attention to the board. The United States Supreme Court is preparing to hear a very important case about birthright citizenship that may very well change what it means to be an American for generations to come. So if you haven't been living under a rock for the last year, then you've noticed a surge in ICE agents all over the country in major American cities. That's immigration and custom enforcement officers being accused of intimidation, harassment, and violence. This has resulted in an increased cases of wrongful arrests, wrongful detentions, and even wrongful death in ICE custody. The question I've been getting is, can we melt the ice? And if so, how? And the answer is simple. The court system remains open to the American public and foreigners alike, and there are ways for us to push back against ICE violations using three tools primarily. The first is the Federal Tort Claims Act, which allows people to sue the United States government for wrongful acts of its agents. Secondly is the Bivens Act. Bivens allows for, in very limited situations, citizens to bring claims against the United States government for wrongful acts of its agents. But Bivens has recently been extremely curtailed by the United States Supreme Court, who is trying to encourage people not to use Bivens in the immigration and customs scenarios. Lastly is Section 1983 of the Civil Rights Act, which is already being used all over the country to hold police officers accountable when they violate citizens' rights, and it normally doesn't apply to federal agents. However, when federal agents are jointly operating with police officers on a state level, then Section 1983 can also be used to hold and check ICE agents and other federal agents for violations of citizen rights. Of these three tools available, the Federal Tort Claims Act has been the most successful tool at holding police officers and agencies, including the United States government, accountable for wrongful death, for wrongful arrests, in detention and custody, and even injuries occurred during the arrest process. And so there is a way for us to fight back, and we should. All right, now to the battle between federal power and state authority. Trump's reliance on federal agents and U.S. Army officials has caused this old fight between what power does the state have and what power does the federal government have when the two are at odds. Operation Metro Surge is the Trump administration's plan to increase ICE agents, officers all throughout the city of Minneapolis, Minnesota, and other parts of the country as they try to meet their ambitious immigration quotas. Attorney General Keith Ellison has argued that the Trump administration policies violate individual rights in terms of our right to protest, and they represent a violation of the First Amendment, but he's also said they violate state rights. And now to the battle of state rights versus federal authority. President Donald Trump's reliance on federal agents and U.S. armed forces has revived an old conversation about where does federal authority end and state power begin. And Attorney General Keith Ellison of Minnesota is doing his best to answer that question in a lawsuit that he's brought to challenge Donald Trump's administration's actions in Minneapolis, Minnesota. Attorney General Keith Ellison's lawsuit is said to be directly responsive to Operation Metro Surge and the murder of Renee Good in Minneapolis, Minnesota earlier this year. The United States Supreme Court has agreed to hear a case concerning birthright citizenship. Now, Donald Trump on February 20th of 2025 passed Executive Order 14160, limiting birthright citizenship to not include people who were born here in the U.S. to undocumented parents. In 2025, the Ninth Circuit courts blocked President Trump's executive order concerning birthright citizenship as plainly violating the language of the 14th Amendment that calls U.S. citizens anybody born in the United States. In a case entitled Trump v. Barbara, the United States Supreme Court has agreed to hear arguments this spring about birthright citizenship and whether or not a sitting president can limit a constitutional clause, specifically the 14th Amendment, by executive order, or whether or not the executive order violates the Constitution and should be struck down. Ironically, Donald Trump's lawyers are arguing that the 14th Amendment's plain language about birthright citizenship was only meant to be applied to former slaves and African Americans. Next week, we'll be talking about the Second Amendment and the murder of Alex Preddy by ICE officers. We'll also be turning our attention to international law and how America First policies is undermining our nation's influence globally. This has been your weekly legal brief with Lee, the movement lawyer.